It's great to see everyone. So my name's Rebecca Williams. Amongst other things, I'm a co-organizer of the DC Legal Hackers Group. But I used to live in New York, and I remember going to my first New York Legal Hackers meeting like 5 or 6 years ago, and look at us now. So it's a pleasure to be here. So this panel is going to focus on how do you balance government transparency, super relevant and a great segue from Corey's talk, and personal privacy. These are both really hot topics, and they're going to continue to be probably for the rest of our lives until there's some sort of, if we get rid of the computers or something. Yeah, nuclear war. Yeah.
Too early? Too early for that.
Too early. Okay. So my name's Rebecca Williams. Just a little bit about my background. I've been interested in this topic for a long time. This is an excellent panel. They're all New Yorkers, too, for folks that are in New York, so you could have access to them. Yes. The applause for New York. So my background, I've done open data for a few years. I used to work at the Sunlight Foundation, advocating for local open data policy laws like New York City has. Then I went in the federal government working on some of the stuff that Corey was sharing. And now I'm currently at Johns Hopkins University doing more city work. So going around, I'm going to Columbus, Ohio next, talk to them about data. So that'll be fun. So this space very much interests me. But I'm going to have each person on the panel introduce themselves because I think they will be best at it. Everyone on the panel has also sort of worked in this area for a while.
My name is Dominic Mauro. I'm an Assistant General Counsel at the New York City Department of Information Technology and Telecommunications, or DoITT. I'm here in my personal capacity, and let's get that out of the way real quick. Yeah, I've been working on open data since a fellowship I did the year after law school. I advocated for New York City to pass an open data law. Spoilers, they did. And then after they passed it, I spent the following 5 years pressuring them to improve it, to implement it, to make it stronger, more robust, passed a series of amendments to the open data law, and now I work on FOIL and open data for New York City at DoITT. So.
I'm Chris Wong. I'm currently the Director of Product at a place called the GovLab, which is an action-oriented research center housed at the Engineering School of NYU. We study and build technology that sort of investigates and promotes open governance, not necessarily sometimes with government partners, but not all the time. And it goes beyond just the sort of like the legal mechanisms of it to the sort of broader cultural and normative factors as well. So I think I'm on this panel a little bit less as, while I do have a law degree,
Nice.
I'm a little bit more, I think, of a cultural observer in this space and thinking about kind of like behavior and norms and culture. Prior to being the Director of Product, I was a Presidential Innovation Fellow where I got to work in Washington with awesome folks like Corey and Rebecca on improving governance there. So I've been kind of in this space for a little while, going back to even developing many, many years ago a crowdsourcing platform for improving patent quality called Peer-to-Patent, which ended up becoming part of the American Invents Act several years later. So it's very exciting. Back then, at the risk of revealing how washed I actually am, back then there were not awesome meetups with lots of people attending like this, and there were just like very small pockets of people that were trying to innovate in this space. So this is really amazing, and thank you guys for having me here.
Hi, I'm Rashida Richardson, Legislative Counsel at the New York Civil Liberties Union, which is the New York affiliate of the American Civil Liberties Union. I lead our privacy, technology, and surveillance work in New York State, so I guess I care more about privacy.
This is the
that's what I'll be talking about.
All right, perfect. Okay, so the way I'm going to break up this panel is it's going to be like 15 minutes, like where are we at now, 15 minutes where should we be in the future, and then 15 minutes Q&A from the audience. So I encourage folks to think of questions as we go through. But just sort of to kick off, like where we are now, what laws exist in terms of transparency, maybe more this side, and then privacy over to Rashida. Where are we at in terms of like a legal framework of things that can control this space right now? Like what exists? Very quickly.
Sure. Well, in New York City, at least, there's the New York City Open Data Law, which has served as the basis for open data laws in dozens of locations. I think you'd know better than I would.
Yeah, there's like 85 or something.
85? Are they all based on New York City? Because I know...
They're various... They Yes.
Yes.
Sure.
Now, Sunlight's got
Sure.
this wonderful analysis. They did this textual parsing of open data laws elsewhere to figure out how many were based on New York City's. So, we've got a strong open data law here, and the open data law in New York City, and I guess that means a lot of other places, uses the Freedom of Information law to figure out what the scope of the data sets covered by the law is, and also bring in that privacy framework that's built into the Freedom of Information law, which is great because you've got, at least in New York, you've got 40 plus years of case law and interpretation and everything about what violates someone's privacy that you can just immediately immediately apply to data sets on open data portals and everything, or data sets that shouldn't be on open data portals. But the bad news is that the law to a large extent was written in 1974. Computers were like 60,000 pounds back then, and we've sort of moved on. And it's good that we have a lot of case law, but none of it applies to open data portals perfectly, right? So we've got this imperfect square peg round hole situation as far as FOIL and open data goes.
Great. Do you want to talk about privacy a little bit?
Sure. So we don't have much. Unfortunately,
Whoops.
New York State doesn't have a robust privacy protection, and a lot of our protections come from existing case law interpretations or federal laws. But the same problem, as Dominic outlined with our state and local laws, exists with federal laws, in that a lot of the laws that protect our personal privacy were written in the 80s, so they don't reflect our current.
Computers only weighed 600 pounds in the 80s, so it's better. It's closer. It's better.
So they often don't reflect the way that we use technology now, and it creates problems where, particularly with law enforcement access, you see law enforcement agencies sort of taking advantage of the loopholes in the laws because we're sort of the square peg with the whole situation.
Yeah.
Yeah, and then just given that it's the Legal Hackers International Summit, the other thing that I would point out, and I'm sure there are other folks in the room that know this better than I, next year the EU data directive goes into effect. And one thing that's kind of, I don't know a ton about it, but a couple things that are interesting to note about that are that one, it kind of like lays out rules for how you process data, so collection and usage, but it also actually lays out pretty strong efforts for providing access of users to request their data and get it. So actually saying that there should be mechanisms available for people to get that. And then it also kind of says that everyone that's a member state, obviously being an EU directive, that anyone who's a member state has to meet these sort of minimum requirements. But you can very easily imagine how that could start to set up conflicts of law further down the line, particularly if you're in this more sort of globalized society where you're transferring data between companies in the EU and let's say America that doesn't have the same kind of standards. So there's a couple other, right? So I would caution not to treat it ever as this kind of like within a vacuum, right? Like this sort of small space, but at the same time, we have folks like Rashida and Dom who are trying to like make this stuff work on a sort of more local level.
Yeah, I'm glad that you brought that up, Chris. So another just sort of like from my past like federal perspective, in terms of privacy protections in the US, you have the Privacy Act, you have HIPAA, you have FERPA, but it's like very siloed, specific types of privacy protections and types of things that you can request, where in the EU has much broader scope already, even before this data directive, but it does not exist in the United States right now. And then also locally, for what it's worth, San Francisco actually wrote this into their last iteration of their open data law. And I guess it's worth mentioning too, like not most jurisdictions have open data laws. They have sort of like programs or executive orders. So maybe, and then of the ones that are laws, most of them will point to their local freedom of information law, but that's different state to state. So it varies. But San Francisco also has like a My Data provision that they're figuring out now. So you can ask San Francisco, what data do you collect about me? And they're trying to figure out the best, like, the way to implement that effectively is like very difficult with all the different departments and agencies. Okay, so next question. So we talked a little bit about laws. What are like other legal mechanisms, and then also probably norms is something I want to talk about, like what exists now in terms of getting data and then sort of protecting personal information. So it's a pretty wide open question, but I'm thinking like contracts, sharing agreements, terms of use, just what actually happens on a norms basis. This is a question for anyone. Any anecdote you want to bring up? Sure. I think one of the norms that I was most baffled by when I was in the when I was a FOIL and open data advocate was there's this whole galaxy of data sets that get shared via memorandum of understanding with third parties, right? So the NYPD, they until very recently didn't publish very much crime data on the open data portal. But they would give it to anyone who asked if they were a researcher at, like John Jay College or something like that. And that's not just because there happen to be a lot of people who go from working for the NYPD to studying to get a degree in criminal justice at John Jay, but I'm sure that helps. So, and this is lots of agencies and lots of just existing relationships with academic centers, right? And then there are probably for-profit centers too. I didn't do much of that when I was an open data advocate, but it's baffling how much data is not open. It's just available if you have the right kind of relationships institutionally with the right kind of agencies, and you just sign an NDA and you can do whatever work you want with this stuff. So. I don't know. I'm going to interject real quick. I love this topic, so I'm just going to answer my own questions. Oh. I was just at this news conference, and one of the reporters gave this hot tip where they were like, if you want to know about a nice data set to FOIA for, you should look at academic papers and look at the footnotes, because academic institutions have access to certain data sets that aren't really readily known, and they're good news stories. So you're just reading academic papers and then sending a public records request for that data set. Yeah, that's brilliant. Yeah.
So one of the things that I find myself particularly interested in terms of privacy and data is the fact that you're dealing with, at any given time, you're dealing with actually a lot of moving targets, right? So you have internationally, and legally, within the legal structures, you have the moving targets of say, again, the US versus the EU data directive, right? But then you also have this moving target of a generational cultural shift. So Gallup just had a poll out recently where 80% of millennials feel that institutions keep their data safe and secure. A smaller percentage of that, 44% of them, said that they believe that these same institutions keep their data private. So what's kind of just interesting about that is that you have this generation of people that are growing up into this society where it has always kind of been the case that the price of entry into participating in this particular society is that you have to be a little bit more sort of freewheeling with what you're willing to put out there on the internet, right? So you have those kinds of moving targets in terms of the sort of cultural aspects, but you also have this moving target, a giant moving target of the technology itself, right? So just curious, show of hands, does anyone actually know how a social security number is created and distributed in this room? Are you guys? So it turns out that actually social security numbers are really easy to sort of re-engineer based on a very limited set of parameters.
You just add one to your own, and that's somebody else's.
Exactly. Well, so one, that's someone else's. But you could target it.
It's true.
You could actually try to target that, right?
Oh, okay. Right.
And it's based on things that you guys, everyone in this room puts on, say, social media, and not even in a insidious kind of way, right? So literally all you need is a little bit of social engineering and add in a hometown and a birth date. And so Alessandro Acquisti, who's a researcher at CMU, has been doing this work for years, and he's able to re-identify with an amazing amount of accuracy a social security number based off of those 3 factors, right? And so and I think he started doing that research probably 5 or 10 years ago, right? And so you have this thing where we can actually re-identify. We can sit here and say all day long, governments should not put out data sets that include PII, but the reality is that even without PII in any given set, the combination of those sets without PII can actually be re-engineered to give you the PII that you're looking for. So in some ways, I know this doesn't really answer the question in the sense that it doesn't govern anything, but it does lead to this sort of context where you have to start looking at places that, ways to actually govern that kind of behavior that is incredibly unpredictable.
Awesome. Any legal mechanisms for privacy that you feel are ineffective or particularly effective that aren't informed by a law?
Are not informed by the law?
Yeah. Sorry, that's weird. Or I can ask another, so something I've just been wondering about generally, and this is related to balancing certainly protection of civil liberties and gov transparency, but also privacy, is I knew in Chicago for a while they weren't collecting stop and frisk data, and the ACLU unit there was advocating for them that you have to collect stop and frisk data so that we can prove that stop and frisk is discriminatory. And then there's been these license plate reader cases in Oakland, but I feel like a lot of folks have been when should the government have to collect quote unquote PII about you to protect against discrimination? Do you understand the question? I think there's a balance here where you don't want too much collected about you, surveillance, but then also you need something collected about you to prove if these systems are even working for everyone.
Yeah, so I think it depends on the type of behavior that you're trying to understand. So with stop and frisk, there's obviously a problem there because certain demographics are being targeted. And as much as civil rights communities and community leaders have been saying this for decades, it's the constant pushback is we don't have data to prove it. So that's why not only in Chicago, but even here, there's a lot of transparency measures that are being passed by local governments just to get data because you can't solve a problem if you can't properly identify it. So to date, a lot of what we're relying on is, I don't want to say it's anecdotal because it's actual life experience, but people's experiences, and it's hard to pass legislation just based on personal stories. But I also go on the extreme of I don't think there's any utility to license plate readers.
Oh, interesting.
Yeah, so because mass surveillance I think is much different, and that paints a different picture about each of us, so it's a lot more information being captured. And I'll stick to license plate readers so I don't take us completely off the rails, but license plate readers, I'll just explain the technology. It's a device that's attached on police cars and then sometimes on repo vans and other, it depends on the company that's running it, but it's a device that goes around and snaps photos of license plates, and then that's put into a large database, and then law enforcement can use that to find people. But the problem is that if you're constantly having cars roving around capturing where a car is, you can actually start to see patterns. So if, I keep pointing to this black Jeep, but there's a black Jeep outside, and if it's always parked on this street or around the corner because of alternate side parking here in New York, then you're pretty likely to know whoever owns that car and may be associated with that car seems to be in this general area, so you can track them down. And you can also, if then you add on other technologies like red light cameras and other cameras around the city, then you can just track someone's movement. And I guess some people may be comfortable with that, but there's a lot of information that can be revealed by just seeing your movements, who you're associated with, what you do in your free time, and that type of information I think most people find to be extremely intrusive. So I would want to know what is the meaning beyond having to look for a specific person, which could be identified through traditional investigative techniques that warrants that type of breach of privacy. So I think it's a balancing test, but I personally, not in my ACLU capacity, don't think there's a need.
Well, right, and the ours is written on this pretty extensively, I think, and Ars Technica, and they don't actually solve any crimes, right? Having this huge database of where every car is in the city all the time, and they don't solve any crimes using that information. They just like having it so they can poke around with it and give it to journalists accidentally because they don't understand what they're giving away when there's a FOIL request.
Yeah, and the trouble is too when that we're talking about one specific technology, but when that's then added with all the other information available, I don't want to make it seem like we are in the minority report, so I'll just leave it.
Yeah, I'm starting to feel really good about having my dystopian YA novel outfit on today. Because you have to add in those other things, right? So if you are living in a society where people are actually you've grown up and you've never known anything other than the fact that everyone can track your car at any given time, that starts to present some really big obstacles in terms of how you convince anyone, policymakers at any level, that they should care about that particular set of interests, right? And and maybe this is for later in this conversation, but that's not even getting into the actual discriminatory bias of data in general, right? This is just talking about oh, we're using this for what we say is a particular kind of purpose, but we'll see, right?
Right, and because FOIL at least was written so long ago, the specific language ours uses, and this is our FOIL, not Ars Technica, the specific language that New York State's Freedom of Information Law uses is you can't disclose information that would be an unwarranted invasion of personal privacy, right? And so that's sort of based on your expectation of privacy, sort of like the Fourth Amendment, right? Unreasonable searches. So if all you know is growing up in this society where, yeah, every cop has like 60 cameras on them capturing license plates all the time, then that's not that unreasonable to think that your license plate's published, right? So our only defense against that is the fact that judges are a couple generations older than most of us, right? So their expectations are on this like lag time, but eventually there'll be millennial judges who are pretty cool with that. Pretty cool with that.
Ooh.
Just saying, we got to update the laws before millennials are judges, guys. Come on, get to it.
I'm going to be thinking about that a lot. So, okay, last question.
The bench will be lit.
I'm about, as AF. The bench will be lit AF. So last question until I segue into like, what will the future be and what should it be? Because I know you all have opinions, but this is sort of like the segue and what you all were just touching on. A lot of these like reasonableness frameworks or frames of reference and balancing tests exist. I guess something that I come up against a lot with sort of open data advocacy is anything that gets into addresses. But a lot of address info has been available. Like we used to have phone books delivered. You could look up somebody's address in the phone book, but now it's just like quicker. And the quickness is what makes it uncomfortable and also more dangerous. So I guess it's just any follow-up questions on sort of like where these balancing tests have been applied, or maybe like license plate reader. I'm gonna talk to Rashida more after this panel because I'm like maybe they're important for discrimination, but maybe don't post them online. But okay, addresses. Let's talk about the balancing tests of addresses or other PII that you want to talk about, and how you've seen these tests applied, and do you think balancing is to date like as rigorous as it should be, or like riff?
It's a little complicated because this implicates the third-party doctrine, which I feel like there's a lot of opinions about that. But that's essentially the balancing test to me, is if it's information that you handed over to a third party. And the case that this came from was originally phone call log. So when the way phones used to work is that it had to go through the telephone company, and it was part of their business record to log the numbers that you were calling and receiving. And so you didn't have any right of privacy in that information because it was being handed over to a third party, and that's where the third party doctrine came from. But then it kind of spiraled out of control, and now it's like any information you hand over. But then there's this larger question that Thurgood Marshall actually raised in that case, was like how voluntary is, because if you have no adequate alternative, then is it really voluntary that you're handing over this information to a third party and then you lose all rights to it? So, and I think that sort of question that he posed in like 1950, I can't remember the case years, but is something that I think is becoming more of the debate, because more and more we see that we aren't given alternatives. It's sort of like, unless you have means to pay for a private email server, then you have to go to Google or Yahoo or free service, and then you give up certain rights in what you hand over to them, and then what they can then hand over to the government or elsewhere.
Yeah, and I think it's heavily context dependent too, right? Like there's no one rule for this. So like people's names, right? The 311 in New York City, you call 311 to complain that there's a suspicious looking Jeep that's been parked out there for the entire panel. You call 311.
It's like the fourth or the fifth panelist, the Jeep.
So you call 311 to make a complaint, and your name is private, right? Like we can, New York City will publish data about that complaint. They will, if someone foils for that complaint, they'll get a lot of information about the complaint, but they won't get the name or phone number of the person that made that complaint. there's just a very strong privacy interest in having people or helping people make anonymous complaints so that people, say something when there's sketchy Jeeps. So we don't publish people's names. But I was a registered lobbyist for a number of years, and my name was public in every meeting I had with any elected official, right? My first and last name and where I worked and how much money I made and everything. So the context is hugely important for these sorts of balancing tests, and there's a greater public interest in knowing who's meeting with whom and trying to influence elected opinion, only to get better open data laws, guys. It's cool. Than there is for people complaining about their neighbors or something like that. So.
Good. Okay, so let's talk a little bit about the future. So we've talked a little bit about how a lot of these laws were created decades ago, that we have baby boomer judges, but how has new technology sort of changed the interpretation of these laws and also made it necessary for new laws? So I think there's an AI.
Yeah.
Yeah, an AI.
So one thing that I've been looking into more is the use of artificial intelligence-based technologies used by government agencies, and so that could be like data mining and other data algorithm programs. I'll stick with predictive policing because that's something you see in the news and people are somewhat familiar with. So that's a form of AI-based technology. But the problem is there's not a lot of clarity around the underlying algorithm, which I'm not a technologist, so I can't get into the problems there, but I know it's a problem. And
Weapons of Math Destruction. If you haven't read it, here's my pitch.
And then there's this problem where I think local governments everywhere are very excited to use new technologies, but not necessarily thinking about the consequences and implications. So they may not be reading the contracts as closely to see who owns the intellectual property rights. And then it's not until you want to end that contract you realize all the data inputs that you've put in and all the analysis that's come out you no longer own, and now this third party owns. And what does that mean for the residents of your city, that all that private information that a government agency only has was put into and now a third party only owns. And then there's also just larger questions about how it's being used. So to bring full circle, it comes back to discriminatory practices. So if you're using bad data, it's not that the algorithm's wrong, it's that the data's bad. So with predictive policing, the problem is that you're using old police records, which capture discriminatory practices, and if that's then the info that's being input to tell police where to go, they're going to go to the same neighborhoods they were already over policing and then finding crimes that may not necessarily have been there, but just if you're being over policed, it's more likely to find stuff. So I think there's a number of issues being created but aren't necessarily being evaluated, and it's kind of the same problem of how we see laws or technologies outpacing the law and how to regulate the technologies, but also the technologies are outpacing government functions in a way.
Yeah, I mean, in many ways it's a participation problem. So thinking about the sort of discriminatory basis of biases of data, right? You have these two sorts of, right, that you can kind of, and this is all work from Kate Crawford and Meredith Whitaker, and they're launching this amazing AI Now initiative on research in sort of the human context of AI. But broadly speaking, they talk about how you can kind of bucket those into two things, right? So one is where the data itself does not reflect the actual reality on the ground. And then the second being that the sort of process that you're trying to measure is actually flawed as well, right? So they cite the example of if you are trying to take promotion data and figure out what kinds of characteristics people should have that would lead to having promotions. Well, if you're basing that all off of men getting data that is largely about men getting promotions, you're going to start citing the wrong characteristics really quickly. And so I think in that particular context, two of the sort of recommendations that they've made that I think are observations that they've made that are really interesting are recognizing, one, that the AI technology tends to run as a sort of background process, right? So there's very little opportunity at any point in that chain to really challenge, one, the analysis, or two, the actual efficacy of the algorithms themselves. So we can identify it here, but what if, where do we go with that, right? And then the second part being that largely artificial intelligence research is being conducted in mainly a technical realm, right? And it's then being applied in this sort of more like social space, but you don't see the sort of participation of, and this is what Kate and Meredith are trying to fix, but you don't see the kind of participation in the sort of technical research that's building this stuff of people that are coming from the sort of more humanities type background. Cascading from that, you also don't have people that are participating in it, right? Like the kinds of consequences that you have of bad algorithms and discriminatory data are going to largely affect groups that have no voice in the system to begin with, right? And so all we're doing is taking that effect and cascading it further and further down using a technology that, like, I've been working in technology for a long time. I don't understand artificial intelligence and algorithms. Like, it's crazy and naive for us to believe that the folks that work in the top levels of government also understand it at the sort of granular level that you need to.
They definitely don't. I know that.
Yeah.
I know that from firsthand experience. Okay. So what about? We talked about context a little bit. Open algorithms seem imperative in like government functions, right? But they probably should exist all over the place, even in private functions for accountability purposes. But I guess what areas do you see as being super ripe for either like a new law or an amendment to an old law? And this could be like data set specific or government programming specific, but something to do with government and transparency or privacy that you're like, this has to happen now. And this is where you can get on your soapbox.
So this is where I make a pitch. We're actually working on a law in New York City called the Post Act Public Oversight of Surveillance Technologies. And what it's trying to do is bring greater oversight and transparency over the contracts that government agencies this bill is specific to the NYPD, but the thought is start with the problem and then expand to other government agencies. But it's to create more transparency and oversight mechanisms about the contracts that they're entering, so you don't necessarily have the problem I was just bringing up with the AI-based technologies of, you would hope that if there's more participation, or at least people are allowed to have the basic information about what's being acquired and used, then you can have more experts chime in and say, well, you should be looking for these security flaws, or maybe you should be making sure that the intellectual property rights aren't all to the third party, so you lose it when the contract ends. But also that we, as residents of this city, have a better understanding of how these technologies are being used, because to date, a lot of what we know are based on FOIA litigation that my office and other civil rights organizations have used, and that's both not economically the best practice, but it's also hard to then talk about these issues in a comprehensive way because we don't fully understand the problem, because we only have access to a limited amount of information. And this bill was introduced in March of this year. We'll see what happens. If you're from New York City, call your local council member and tell them to sponsor it.
Do we have any council members with us? We did last year. No, not this year? Too bad.
Well, call your council member and say you care. But there's also, if you're not from New York City, there's also similar measures being introduced around the country. In fact, this week I found out Seattle just passed a very similar measure. I can't go into the specifics because I need to actually read the bill, which I plan for next week. But it is kind of part of this larger movement, because it's also help investigative journalists. It's not just all lawsuits, but it's too much of us finding out after the fact and after there's been substantial problems or some type of lawsuit related to the practices or use of the technologies. So that's one way we're trying to create transparency.
Awesome. Anyone else? Ripe?
Yeah, so I don't know about a particular topic area, but one thing that I will say is that a couple things. As Corey and Rebecca have been doing for a very long time, and particularly the Obama administration, bringing technologists into government, what we really need is to continue that tradition of making sure that there are folks that are operating at the high levels that actually understand the way that these things work. Because at the end of the day, data is hard. Right, and I think in some ways we as technologists do ourselves a really big disservice, because it's really hard to go into a conversation with someone and not be like, oh no, it's easy, I can scrape that and we can do this. And while that may be true on a like case-by-case basis, as a larger thing, like data is hard. There are people that like have been studying data science for like a really long time that like aren't necessarily actually being consulted with making these kinds of decisions, right? And so I think that there's that. Let's get more technologists and folks who understand and like data scientists into government and into these sort of like consulting places. But then the other large area I think that we can probably make an improvement is in human-centered design, right? It's 2017, we're still not doing a very good job of designing these systems to collect the information in a way that's actually collecting them to be relevant, but that can be in sort of promotion of privacy or maintaining privacy standards later on, right? We're still thinking about it in terms of like, fill out this form, and this is all the information that we think we need, so now fill out this form that's actually not very intuitive to begin with, and then just give us all this stuff. And we're gonna keep it private.
Right, just from like a data management perspective, when you're collecting the information, are you putting it in a privacy bucket or an open bucket? Is it encrypted when you're filling it out? But it doesn't happen from day one. It sort of gets collected, and then folks try to figure it out later on.
Well, and also the reality of being in this like sort of era of microservices where we're not, right? Like the idea of like an agency using a single piece of enterprise technology to maintain that entire thing is a lot different than like where we are today, where you have things like Department of Better Technology that are deploying like the form building services, using Stripe as the payment services, using blah blah blah, right? And so it's like, again, you have to be super aware of these sort of cascading effects that you'll probably see.
Yeah, and even before we can get to human-centered design, like government's using spectacularly old technology in so many areas that they can't do their basic jobs sometimes, right? Like when I was an open data advocate, I wanted to get more information out on open data portals and everything, and I do that professionally now too. But it's good disclaimer. But this state agency that's responsible for overseeing this entire class of corporations, right? They have to file some paperwork with them 3 times a year, or 4 times a year. And it goes into a big database every time they file their paperwork. And we said, well, why don't you just publish all the people, a list of agencies, or a list of corporations that aren't complying with these regulations? And they said, we can't actually do that search in our database. Like our main job is to oversee whether people file this really basic form, or corporations file this basic form of paperwork to maintain their status, right? And we can't do that search. So like, on the one hand, your privacy is safe, right? Because government probably can't screw it up because they can't even get it to do their day jobs in a lot of cases.
I think that's real, actually.
That's so real.
Like I think there's
I'm trying really hard not to identify the agency, but very broad.
No, I just mean it's like the poor technology does help you with your privacy.
Absolutely,
Yeah.
absolutely. But then
trade-offs.
But then I think it's long overdue to sort of regulate the surveillance capitalism that we exist in, right? Like everything you do is logged, and Experian advertises on WebMD, so they know when you search for something that might be cancer. Spoilers: everything might be cancer. We all know that, yeah.
That's a good one.
Right, so they know like from the moment that you, before you go see your doctor, right? They know like at 3 a.m. That you think you might have some really significant medical bills coming up. And used to be half of all bankruptcies in America were caused by medical debt. I don't know if that's still true. Thanks, Obama. But it's ridiculous that that's allowed, right? I mean, I don't think
that explains some of my ads.
Right?
Yeah.
No, so it's not like HIPAA ought to apply to WebMD, but like there's some middle ground here that's it's past time we regulate some of this stuff.
Awesome. Okay, so I wanted to leave time for questions. What's the best way for web streaming? Should I just restate the question, or? Okay.
Whoops, test. Here it is. So.
Should I pass it around, or?
Well, let them pass it to each other.
Okay. Raise your hand if you want to be next. Yeah.
Okay.
It's you.
Yeah. All right. I'm the first. Hi guys. You mentioned that open data is not super regulated. It's not very clear. Right? Legislation is quite old. So it is quite the same in Ukraine. So I want to give you the case that happened lately, and what would be your suggestions or what's your point of view? So we have this open data sets. It's also in Ukraine all about open data now, right? It's very popular. and there is a publicly available data also, right? And there is a company that was parsing or using the robot to scan the website, right? Like including legislatures and administrative sites, etc. So they were collecting this public. They were collecting this publicly available data, and they were making a data set, and they were selling it, right? Oh, yeah. So how do you perceive? Yeah, and what happened to them? There was a search warrant. Police came, and they had troubles. But it wasn't really regulated, So at some point, regulators said, "Okay, this is unlawful," and they, did this. So
were they arrested because of what they were collecting, or because they were selling it, or both?
Oh, probably both.
Okay.
Yeah. Do you have any cases or?
My take is there's whole institutions in Washington D.C. that make a lot of money off of aggregating public data and selling it.
Yeah, I think on the one hand, government data ought to be available to anybody, right? I think, I think, well, there are companies that spend an awful lot of time and money increasing the cost of hosting data because they just scrape data sets constantly every second, right? And there's probably some avenue for cooperation to the government could let these companies know when the data set's going to be updated, so maybe they just scrape it for one day instead of 24/7 every day, every month, waiting for the data to be updated. But I don't think it's necessarily the worst thing for companies that are going to clean up the data to have some sort of license or I'd like people to be able to use the data to find out what their government's doing, but if government's not going to spend the time to clean up the data and make it eminently usable, I don't think it's the worst thing for companies to be able to do that and turn a buck off of it. It's just if you could turn that into a virtuous cycle where this company pays for access to this data and the government has more resources to open more data so companies can get more data, right? I think that'd be great, because I can tell you that open data and transparency and FOIL and everything like that's not well funded generally.
Yeah, I guess just real quick, I think if it was like benign, regular public data, like census data, you're cleaning it up and you're reselling it and you're joining it with like housing data or something that exists. That's like Zillow. It's a very successful company. But if it's something that you're only supposed to download a little bit of and not a ton, this is like the Aaron Swartz CFAA thing. So you would get in trouble. So I think it would matter what type of data, but if it was just sort of regular public data, that's okay. You wouldn't get in trouble in the U.S. And in fact, we have a lot of companies that make a lot of money off of that.
Thanks.
Yeah. Is this a perfect system? I can. Hi.
Can you hear me okay? Yeah?
Yes.
Okay. So I'm wondering about kind of decentralized mechanisms for collecting individual practitioners' knowledge about the data that's collected, how it's used, and the impact of those systems. I'm a criminal defense lawyer, and what I find is that there's different onus for the state to disclose information in criminal law, and that could be used advantageously for pursuing civil claims or just changing legislation because you have more information. It also seems economic, but it also what I'm finding is there's an unwillingness to disclose many things which are relevant, but it only takes one or two kind of unprepared witnesses, or police witnesses, to disclose some gem which, as our kind of criminal defense practice is set up, really doesn't get communicated to the to other practitioners who could use it in their cases, but also to kind of more to affect policy aims that they are invested in. So I mean, I'm wondering if you can speak to either examples of kind of crowdsourcing from practitioners, useful databases, if you have examples of those, or if you can kind of outline maybe a process where you could see that kind of successfully unfolding.
Yeah. Well, Rebecca, you can correct me if I'm wrong, but as I understand data.gov, it's almost exactly that, right? Like data.gov is a really great example of, right, data.gov doesn't itself house any of the data, but it's like agencies kind of coming together to like, in like harmonious.
I love the idea. I can't call it great because it's not comprehensive enough. But the idea is like an inventory of data sets, and you have a lot of local governments doing this as well. And this is a lot of the government transparency folks at this point, like that's like the first thing that you ask for. It's like, please open all the data, and please, before you do that, can you give us a list of what those things are? But like I said, there's a lot of things. There's only certain jurisdictions. The feds are supposed to do this. They don't do it completely. That are actually capturing sort of not public data, but restricted public and not public data. So like anything that a government is collecting is supposed to be captured in this federal inventory. There's like an IT dashboard, and then California just passed a law last year, SB 272, to inventory all their databases. I know that that's also not complete for the inventories, but the idea is there. Like there are some laws about this. A lot of the inventories are incomplete, but like I mentioned from that like journalist tip, like looking at like academic cited databases and then just sort of doing a public records request there. I see like, I don't know a sharing space to think about unprepared cops that accidentally mention a database, but
yeah, I mean, I just think it serves as a good model of how you could imagine something like that working. I think the reality is, I don't know a ton about this particular space. The reality is that that movement's probably not quite there. I do know that there are folks like, I don't know if you're familiar with Rebecca Wexler, and she's just done a bunch of amazing work at Legal Aid Society and Data and Society this last year. So I would totally suggest looking at more of what she's doing, and I think that what you would start to do is find folks that are like you, that are interested in being able to find that. But I do think that there's probably a huge, there's an obstacle here that potentially you're the person to overcome, of like sort of getting these people to actually want to do this, because the data's there, and it's not just, it's going to be in weird places, right? And I think it's, people just have neither. Yeah, by the way, the other thing about open data is that it's like you can make it accessible, but is it actually useful, right? So like if you're putting it out in PDFs, then like that's a completely different problem. But that doesn't mean that it's not there, and that doesn't mean it's not something that you could actually like convince like a community of folks like you to sort of build a movement around.
Yeah, to build. Yeah. Thank you.
maybe one or two more questions. I think we're supposed to stop now, but we started a little late, so I'm okay. Let's do a couple more questions. Here, wait, I'm gonna walk around. Raise your hand. I hope this doesn't go off. Okay.
Hi. Hey. Okay, so just a question. Just that last bit when you were talking about the Google recommendations, I've kind of heard that on podcasts, similar kind of thing, where they. It seems like the panel focused a lot on public data sets, and I was wondering if you guys would kind of let your minds roam free if you big, if we could do big things, like the public-private distinction, right? It's like Google and Facebook, they have all information about our lives. Do we know anything that they're doing? Is there any form of accountability? If you could reimagine the institutional framework, like for example, like privacy by design? I don't know if you've given thought to things like that, and just I'd be curious to know your thoughts.
Well, one specific thing comes to mind, and I keep feeling like I'm going back to like law enforcement issues. But just to talk about like private collection, so yes, Google, Facebook, Twitter, depending on how much you use, all of those services have a lot of information. And this is the problem where federal laws governing access to that information is outdated. So anything past 6 months and everything can be collected without a warrant. And it gets back into this cycle of the problem of like, then how much do you trust government agencies with that information? So like, I think privacy by design is something that some of these companies are thinking about from some of the work that I've been doing with them, because we're actually like allies on these issues around personal privacy. They care too because they understand it's good for business. But I also think that's where like the role of advocates can come in, because companies will do anything that will help the bottom line. So if they recognize that something is important to their consumers, then it's not that they necessarily shift their practices, but they may start to think about it in a different way that may be better for how your data is collected and stored.
Yeah, I mean, they collect the data and keep the data that we're willing to give them, right? So I mean, if you want to ask about whether or not there's something structurally that can change about that, I mean, like it all comes down to what we're willing to do, right? Like I said, 80% of millennials have like trust that their data is being held secure, right? And like that's a huge number. And so the idea that like you can change whether the sort of there's this bottom line to any company that's going to say like we can collect this data, we can monetize it, but that is only useful if like we're still willing to give that to them, right? I mean, I'm a blast at parties and when I talk about this kind of stuff, but like, I come off as super paranoid, and I think that like largely, proportionally, I'm probably, and people in this room are actually probably in the minority of like sounding like we're a bunch of crazy people that don't want our retinas scanned from 10 feet away. But like, for a lot of people, that just doesn't matter. So I think we'd have to reimagine kind of both the sort of like educational system, right? The idea that there are things that are happening. It's not necessarily that I'm scared of Facebook or Mark, right? Like Zuckerberg is like, it's that Facebook has the largest faceprint database on the planet, and your faceprint is valid for 25 years. So I'm not scared about today or 5 years from now or 10 years from now. I'm scared of what's going to happen 25 years from now when Facebook sells their giant faceprint database, and then what, right?
So I'm even like a rarer person in that government surveillance does concern me, but I see all their successes via these corporations. And I'm terrified of corporate surveillance. Like, I'm very, very serious about that because their collection is so much better. Like, I know a lot of folks that have worked in and out of these big companies like Google and Facebook and some of the things that Uber is doing now. Like, their collection is so much better. A lot of folks, there's a lot of argument. Some people will talk about, like, what happens when the big corps have better data than like the census, like what's going to be more authoritative. And they do now, we just don't use it that way. And I think it's very like scary and unbalanced, and if like thinking big, would have like a very intense regulation scheme on all the corporations collecting data.
Oh yeah, absolutely. I mean, in the aftermath of the Great Depression, right, or actually maybe in the midst of the Great Depression, the Securities and Exchange Commission Act, we regulated automobile manufacturers in the 60s and imposed the emissions regulations. That's, prevented global warming. Obviously, the problem's been solved, but with regulation. So it's imperfect, but like we got to give it a shot. I mean, you can't just let Facebook and Google collect our information and monetize it and store it and everything.
Don't vote for Mark Zuckerberg for president. Just don't do it. Please don't do it.
Now vote for Jeff Bezos.
Yeah, Bezos.
But I do want to
kind
of go back to like, I think it's also like we need to stress personal responsibility in education, because it's like we can try. passing regs and laws are very hard and very slow. So and even though that's my job, I have very little faith in it. So that's why I think it's all like my personal thing is like we need more public education. We need more people to care, and we need more people in privileged positions to care about those who are more vulnerable to these practices and more likely to be harmed, because then you can sort of have a greater consciousness and all boats rise kind of thing. But I just don't think regulations and laws are the solution, because we kind of have to change as a society to care more about our information. And
I mean, one of the reasons that there's so many opportunities for the folks in this room that are trying to disrupt legal institutions is that law is largely reactive. And so like we're, the extent to which that we can actually get people to build a framework ahead of time, I think it'd be more powerful, I think, than trying to like create a series of laws that actually like try to change the problem reactively.
I'm going to do a small pitch. In DC next weekend, DC Legal Hackers with the ACLU DC chapter and also Georgetown Law, we're doing a digital privacy training for anyone that's interested. If you're in DC, you should come. But also if you're another DC Legal Hacker chapter organizer, I've tweeted this out before, but come to me and I'll share the info. It'd be great for you to mimic sort of these digital privacy trainings in your local chapters, and also to the extent that you can partner with a local ACLU chapter, we're starting to do that. So I think that is a really good thing. So one more question from someone who hasn't asked yet. You have to come up front.
Armin Rashiki, or whatever his name is, from the mayor's office, has talked about data deserts. There are areas of people that, where their data don't get counted. You talked about how, the police land on people, but what about if the collecting of data is to kind of advantage people, what about the people who are being disadvantaged because their data isn't being collected?
Yeah, I mean, there's a great example of this when you look at, again, a lot of like Kate Crawford and Meredith Whitaker's work. So there was this app, I believe it was like City of Boston. It was an app called Bump, I think. But basically it used the accelerometer in your smartphone to measure Boston. For anyone who's familiar with it, has lots of potholes. Basically it measures every time you drive over a pothole, and then the city can actually, the idea being that the city could go out and fix those potholes. The problem being that people who lived in more affluent neighborhoods were more likely to have smartphones, which were more likely to have the app installed on their phone. And then potholes in more affluent neighborhoods were getting fixed as opposed to those that were.
And that already happened before the app, so it just exasperated.
Right, so it's just, so I have a ton of empathy for the question of how do you actually do that. And I think, again, a lot of that comes back to the sort of human-centered design aspect of it. Like I'm conceptually not offended at all by what Bump was trying to accomplish, right? But I think that they didn't really think through what was the best mechanism that was going to be useful for like the largest amount of users, right? Because if you're designing something that's a good idea, but you haven't thought through how it's going to affect everybody, that's going to be problematic. And so I think that we do need to do a lot more of that. We need to bring in the sort of UX researchers, the human-centered designers. We need to get them in much earlier and get them to sort of design systems that could potentially alleviate that pain point.
Yeah, I mean, the thing that I was thinking of is what I brought up earlier with the stop and frisk collection, whether it's happening or not, or then also sort of, there are some articles about it the last census, and I think it's going to be relevant this census too. There's sort of this community shift where folks weren't wanting to fill out their race or even necessarily their gender. Like people are like not wanting to sort of identify in like a personal social way, but in fact we have, protections, strict scrutiny protections for race. So if you don't fill out race in this certain way that we have been for a long time, then it's harder to bring lawsuits in that area. It's harder to sort of shift funds in that area. So I think that there's a lot of, I don't know. I used to be somebody that used to want to not fill things out, just to not, like it's none of your business, but now I'm like, white, very white, very...
But I think it's also, like, before I was mentioning over-policing in certain neighborhoods, so it's also a matter of access to resources, too, where I think you have this tension where the people who are less likely to have relevant information collected for government services are also the populations that are more subject to the problematic practices. So if you look at a public housing building, people who live there or visit are surveilled more than anyone else because there are CCTV cameras around to look for violence or other issues, but it's also because it's like a failure to look at the underlying problem of access and resources. So if people can't access social services to raise problems about needs that they have, but the only means that those are being captured is through a more problematic procedure, then I think it's just a larger question about how we're allocating those resources and how they're being used, so you don't have the skew of like vulnerable populations being harmed by problematic practices, but also not being captured for services or other beneficial aspects.
Awesome. Thank you. Thank you, everyone.
Okay, so this next suite of talks involves teaching law students about legal innovation. And many legal hackers members, legal hackers organizers, many of the VIPs who've joined us today to speak have engaged with the Legal Academy by teaching clinics or workshops or serving as adjuncts. And really these folks, and beginning with, at least in my experience, with Jonathan Askin, this whole idea of breeding the lawyer 2.0. What does the new lawyer look like? So we have people, once again, from around the world who are working on this problem. So I want to start with Jose Torres, who founded Colombia Legal Hackers in Bogota and was most recently at Stanford Law School.
Thank you. So hello everyone, my name is Jose Torres. I'm from Colombia. I'm the director of the Center for Innovation in Law at Sergio Arboleda University in Bogota. And I'm going to share with you a course that we're developing and that we're launching next semester in the first semester of 2018 called Hacking Access to Justice. Okay, so we're really focused on access to justice for low-income individuals in Colombia. This is Bertica. Bertica is a typical cleaning lady in Colombia. She lives in this neighborhood called Soacha in Bogota in the hills, similar to the favelas in Brazil. She spends 3 or 4 hours a day in traffic and of course has no access to a lawyer, access to courts is very, very difficult for her. So the question that we're trying to answer at our center is, this is just a picture of how labor courts in Bogota are. So if you feel that in the US things are messy and that you don't have a budget, you've seen nothing. Like, I don't understand why people in the US complain, to be honest. I just don't. I mean, this is really, really bad. And this is in Bogota. If we move a little bit further to other cities in the country, our problem is even worse. So we really have a problem over there. So the question that we have is, how is academia helping Bertica? What is all of the access to justice research and papers doing for Bertica? Do we need more papers that say we need more resources? Like, really? If you go through all of the literature on access to justice, most of it just says we need more resources, we need more pro bono lawyers. Like, really? As lawyers, that's all we have to say? So we really want to push the conversation forward. Of course, we don't need any more papers. What we actually need, we don't need any more papers highlighting the problems. Everyone knows that we have problems on access to justice. We know that we don't have funding, that the courts are horrible, that they are too long. We already know that. We don't need any more law professors writing on that. To be honest, I think it should be illegal to publish another paper. Just highlight, I think it should be illegal to just publish a paper or another set of books just saying we have a problem. Like, it's bad for the environment. So we don't need any more of that. So what we really need is actionable solutions. And we've been giving a lot of thought around how can law schools really, really contribute. And for that, we've also been going to how other schools are trying to solve problems. And I was lucky enough to be a fellow at Stanford last year. So of course I went to the engineering school, where they are doing really, really, really cool stuff. So I went to the engineering school to see how they were partnering with governments, and there's a new initiative called the Hacking For. And in this case, this is a course called Hacking.
You're failing on this, so I'm going to put this on there. Okay. Speak into that.
Perfect. So this is a new course called Hacking for Defense, where the engineering school at Stanford is partnering with the U.S. Department of Defense to solve really, really, really hard problems. So just some of the problems, for instance, that students are working on are how to detect and monitor illicit maritime activities, data for effective Navy SEAL training, live log independent solutions for veterans with complex injuries. Notice that the problems are really specific. They are not problems around how do we just improve, I don't know, the state of security in the U.S. There's also another course that I took called Hacking for Diplomacy, which has a similar dynamic. The Stanford partnered with the U.S. Department of Defense to focus on problems such as how to, hacking violent extremism online, how to assess the effectiveness of peacekeeping forces, how to create a platform for coordinated response to the Syrian refugee crisis. These are really, really hard problems, and the folks at the engineering department are doing really, really cool stuff around that. So I was thinking about how do we bring this to the legal system. These are some of the tools that they were using for those courses. This is just an example of a mission model canvas. The idea with those courses is to actually create the technology, but also to build the whole system. Not only just to hand in a piece of code, but to think about how much it would cost, who would be implemented it, how much buy-in do we need, who might be the saboteurs inside the agency, whom do we have to partner with. And these are just examples of actual minimum viable products, so platforms that students had to go to the field and actually get user feedback and testing, collect data, and then continue to iterate to see if they could find a solution to the problem. So after seeing this, I realized that it was time for schools to really step it up. With Legal Hackers, the Legal Design Lab at Stanford, a local service design consultancy called Aptica, and my center at the Sergio Arboleda University, we're launching Hacking for Access to Justice. We want to do the same exercise that was done for diplomacy and defense, but to improve courts worldwide. We want to mix lean startup with legal design and technology. We always want to make sure that we're working at the intersection of different disciplines. And what we're going to do is to create teams of interdisciplinary teams. So the teams of students that will be working in the challenges are always going to have different backgrounds. So we're going to have students from CS working with designers, working with law students, policy, economics. Everyone's invited to the party. It just has to be interdisciplinary, and we really need engineers. We want to make sure the students work on real challenges. We don't want deliverables to be papers. We have enough papers already. We want students to develop prototypes, to come up with code, to develop MVPs, to develop website frameworks. So we'll be using customer development methodologies, the mission model canvas, that's the version of the business model canvas, but adapted to government work. And we'll also be using a lot of design thinking. We think that in legal tech, there's a lot of talk around technology, but part of the big thing is just how do we find the problems that are really worth solving, and how to make sure that we're finding the right technology for what. So that's where design, we think, plays a huge role. And we're also working with designers to come up with different tools that hopefully we'll be using. So this is our first prototype of a legal design canvas. It's just basically a customer journey map tied with legal theory so that we understand both sides of the picture. We're working to create other designs. So this is just a design criteria canvas. We're working on that, so please don't use them yet. But the idea is just, we'll be launching this course, we'll be creating the course syllabus, materials, and open source all of that so that hopefully everyone will be able to use that. We'll be explaining how we're setting up the teams, how do teams participate, what is it that they're working, how do we partner with the institutions, just basically creating the playbook for this type of courses. And what are we hoping with this? We really hope to create the largest open innovation movement for access to justice in history. If you think about the access to justice conversation, it would be great to have this type of course being done with our friends from the Ukraine, which are doing fascinating work, our friends from Nigeria, all of the law schools in the US, and hopefully start learning from each other. I'm sure that we can, in Colombia, we'll be able to learn a lot from what's going on in the US, from what's going on in Nigeria, in the Ukraine, in Singapore, Dubai. And if everyone starts open sourcing everything that they're doing in those classes, the website frameworks, the code, customer journey maps, how they're interviewing, even workarounds to legal theory in the different countries, I really think that we can do something great. The idea is to create an open innovation network. The website, I'm working on the website. It'll be coming soon, sometime this year. As soon as we have it, we'll launch it through Legal Hackers as well. And I'll invite you all to help us help Vertica. Thank you very much.
All right. Hey, you're here. Okay, never mind. Go for it. Thank you. No? It's in Keynote, no? It's in Keynote format, no PowerPoint. Oh. Some graphics will crash. Okay, no problem. Hi again. I'm still Denis from Ukraine, Odessa. I'm representing Kyiv Legal Hackers chapter. So now I want to talk about legal tech laboratory Lexorium, a little bit what it's all about. So it started at the 25th of April. We announced at the social media. So we have more than 50 requests. We choose about 6 person to join the laboratory. And we started the basic education. The goal of the laboratory is not a classic legal education. It's not at all a legal education like law school or such another. It's about project-based education. When participants of laboratory came to laboratory with an idea, or even without idea, they know some problem in legal sphere and they want to solve this problem, but they don't know how to solve it using technology. Most of all, they are students, law students, or postgraduate law students. They are not coders, they are not developers, they are not marketers or I don't know, SMM managers. They are have a humanitarian education. So how we do it? All of these companies are very successful and popular in Ukraine, in Europe, or some of them in the world, and no one of them are not connected to the legal or law firms. They are all professional in their sphere, in their area. Let's start from the beginning. So there are 10 lessons in courses, 10 classes in courses. Every course, every class was about different themes. So the first course was a workshop about chatbot creating. It was held by Nikita Podgainy. As Dmitry said, he's an author of Open Data Bot and Bot and Partners. It's a chatbot that help make a legal consultation. So Nikita made a workshop for students, for participants of Legal Tech Laboratory, how to build a personal bot in legal tech for half an hour. So at the end of the workshop, every participant made his or her first chatbot using the bot constructor such as ChatFuel, FlowXO, and etc. That was how it was. At the second session, we talk about business canvas. We talk about the pain and the gain between the customer and client in legal tech. So the participant can analyze their ideas, analyze their problems that we want to solve according to model business canvas. Held by Evgeny Plokhoy, who is co-founder of many successful companies which make applications for App Store and Google Play. The third session, we talk about SMM and legal tech. So we ask Alexander Oleynik, who is founder, executive director of Netocrat Communication, most of the powerful Ukrainian SMM agency, to talk about how to push legal tech project in using SMM social media marketing, such as Instagram, such as Facebook, such as other social networks, Twitter, and so on. The fourth session was about till the 2 days before the Legal Tech Hackathon in Kyiv, which we talked a little bit earlier. So we invited Igor Solodov, who is the founder, who is ex-president of IASIC and trainer who trained how to make a speech in a legal tech project. So we have a practicing. That's Igor, he is up and the down, our participant. He teach how to speak about a project to involve into this project and into idea, into problem solving, more participant for the team. Next one, it was about business safety and concurration. So we invite PhD in telecommunication who told how to protect data, how to analyze risk in a legal tech project. So that was very interesting and very useful information. Next one. Anna Bondarenko, who is, as you see, founder of Hub Volunteer Service, she told the participant about what is the difference between social project and social entrepreneurship, and where is legal tech project in this sphere, or is it must be only a commercial project, or it must be only pro bono project. So we talk about this with Anna. With this guy from Accent Partners, we talk about predictive analytics, legal startups, neural networks, artificial intelligence, so everything that are now in the real hype of legal tech industry. That's our photo. About the project management, we heard today. So we also had a speaker and mentor for our participant, Alex Bornyakov, who is CEO of Vertamedia, Clicky, Intersoc, and many very successful world famous company, even here in the US. So he gave a very good advice to our participant. And two more is about the fundraising for legal tech project. And the final one was about client-oriented service. So can be legal tech idea, or legal tech project, or legal tech product most user-friendly to their clients. How to build this product more user-friendly. And a couple of words. Which projects are now developing inside this laboratory. First project is a legal education chatbot assistant Milana. It's a project which it's a chatbot for the Facebook Messenger and Telegram Messenger. It consists of text information, video information, legal acts. Students can even pass the test inside the messenger without presenting of teacher or professor and so on. For the For the first 2 weeks, without any advertising commercial in the closed beta, we have about 100 users. Now this chatbot is on the closed beta processing. The next one is the online dispute resolution platform, which will be launched maybe, I hope so, at the end of September. It's a really big problem for Ukraine because we don't have even mediation procedure in Ukrainian justice. So this platform must reinvent legislation for Ukraine. And the last project which are developing now in Lexorium laboratory is a project called Codex. It's a legal terms chatbot search. You just type a term that you want to know, and the bot gave you so many requests as he can. If you're interested in my legal tech activities, it's not all that I'm done. You can find information in my website, so thank you very much for your attention.
Cool. So, can I start? Okay. All right. So, hi, everybody. My name is Amy Wong. I am here to talk to you today about 5 things I learned about starting a legal tech company. So, the last time I was here last year, I talked to all of you guys about crowdfunding. I was working in private practice as a crowdfunding and securities attorney. And a couple things really kind of drove me crazy over the past year. One is that every single day I would have to sit down and spend, 20 to 25 hours just producing the first draft of a simple fund document, even if we had a good template, right? And I was like, I can see how we would automate this, and this is a complete and utter waste of my time. I would much rather be walking my dog than spending 20 to 25 hours to produce this first draft. So my legal tech company essentially kind of automated my knowledge base or everything I know. So it's called Bootstrap Legal. What we do today is we automate the drafting of the legal paperwork that people need to raise capital for their real estate projects. So under securities law, this is called PPM, subscription agreements, things of that sort. But I'm not really here to talk about the company today. I'm more so here to talk about the journey. So, the first lesson I learned is that there's never been a better time to start a legal technology company. So I don't know if you guys have been keeping up with the news, but a lot has happened in, I would say, just the past 6 months, right? This is an actual slide from my pitch deck. All these screenshots were taken over the course of 2 weeks, and these are not like legal tech blogs. These are the Financial Times, the ABA Journal, the Atlantic, Bloomberg Markets, and the New York Times, all talking about legal technology and its promise. This is a bunch of screenshots just of news and legal tech from the past, so starting April, it's probably the past 2 or 3 months. Justin Kan, the founder of Twitch, went and raised $10.5 million for his new legal tech company, Atrium. No one actually knows what they're doing yet. Law Geeks just raised $7 million for its Series A. It uses AI for contract review. And I think just hot off the press this week, Ironclad, which is Jason Bomig out in SF, he raised $11 million in funding for his new contract management platform for in-house counsel. If that is not enough to show you that now is the time to start a legal technology company, Jason Calacanis, which is one of the top 10 angel investors in the world, he just released his new book called Angel. It talks all about angel investing. And And in the book, he drops all these knowledge bombs about industries that he's looking at that he thinks are the potential next big wins. And one of the ones he mentions is legal technology. So if you ever wanted to start a legal tech company, now is the time because the money is there, finally. Number 2, haters are going to hate. So first of all, this depends on what kind of legal technology company you're starting, right? If you're starting, I don't know, like a marketplace or maybe a tool to help attorneys manage their litigation, maybe they might love you, maybe they won't hate you. I'm doing a consumer-facing product. Thus, other real estate attorneys have don't like me quite so much. So actually, I started the company in March. We incorporated in April. We did a friends and family round in May, and we just launched last Tuesday. And already, in the matter of a week and a half, I have hate mail. Oh. So this is a message I got the week that I launched on LinkedIn. It's actually an attorney that I've met before in person, I know, which, you know, if it were anonymous, like, who cares, right? But I actually know this person, which makes it sting a little bit. But, you know, this is probably my favorite message so far. I've gotten other ones, but this is my favorite so far because basically she spends the entire message talking about how much I suck and how much no one wants my product and how everybody hates me, and then asks me to send her business and referrals. So the lesson here is grow a thick skin. You know, there's a guy in the real estate industry, and that's the industry that I'm in, and his name is Grant Cardone, and he says, if people are sending you hate mail, you're doing the right thing, so you should double down. So double down. Number 3, the people that you want to get money from might not really understand what you're doing. And I say this on many levels. So I had a conversation with probably, I don't know, like 3 VCs last week. 2 of them were concerned about my market size, which I can understand. And one of them told me, who in here knows what a PPM is? Okay, so a PPM, which is what we automate, is like this complex, 60 to 100-page document that discloses every single possible risk of the investment, because this is a document that you want to give your investors, giving them warning about everything that could go wrong in case they lose their money, right? And the VCs, when they raise funds, they need fund documents too. So I kind of assumed that they would understand why these documents are important. Instead, he was like, you know what? I don't care about legal. I feel like attorneys are always selling me templates anyways. Aren't you just changing the name of this thing and then selling it to us for $50,000? And I was like, I'm pretty sure it's not that simple. I'm pretty sure the attorney isn't just sitting there twiddling their thumbs for 100 hours and then just changing your name and selling it for $50,000. But that's what you're up against, right? You have to find a way to explain what you're doing and why it's valuable and why you're not just a form filler outer to people who do not understand the law at all. And it's hard, it's difficult. Another thing for those of you who are interested in actually targeting the consumer space is that if you're trying to make legal services more accessible and affordable to people, you're gonna run into arguments about your market size. Because the truth is that, they say the legal industry is a $65 billion industry, but the numbers aren't there for the types of transactions that you're going to want to handle. In my industry, where people are, they're paying, a $1 million real estate raise, the legal fees on that are gonna cost, depending on the law firm you go to, anywhere from $10,000 to $25,000. If you're raising $300,000, you're not gonna pay $10,000 to $25,000. And so all the VCs ask, well, we don't understand, according to SEC data that you've presented, there's barely any real estate transactions less than $1 million, because they don't understand that the market isn't there, that's being underserved today. So that's what you're up against. Number 4 it forces you to really understand your clients. So I started my career first with the federal government as a regulator. Then I went in-house as general counsel at a startup, and I thought because I was the client and I was hiring the attorneys that I really understood what clients want, because I would get annoyed at other attorneys for stuff they did to me, right? And so when I went into private practice, I was like, I get it. I get what clients want, and just did my legal work all day long. When I started the legal technology company, it made me realize I don't know shit about what clients want. And the truth is, sometimes your clients don't know what they want either. You have to sit down with them and figure out what they want, what process they want, how much can they pay, how much do they want to pay, right? How can you make this easier for them to understand, because they don't understand the law either. And I think for the first time, it's been an incredibly valuable exercise to actually sit down with my former clients and say, hey, what do you actually want? Like, what could we or any other lawyer have done better? And one example of this is, all my clients over the past year under the age of 35, every time I gave them wire instructions for my retainer, they're like, hey, can I Venmo this to you? And I'm like, no, you can't, because then I have to sit here and write a check and find an envelope and a stamp so that I can pay my law firm, so that your retainer doesn't end up in my personal checking account. It's in like the client trust account, and they don't get it. All they know is they don't want to go to a bank and send a wire. So these are the type of things I'm talking about. And the last thing is, and I don't think this is just specific to legal tech, this is any entrepreneur in general, is it forces you to really listen to yourself. So I think when everyone thinks about starting a startup, they think this, like everything's glitter and unicorns and it's so great and we're gonna be our own boss and gonna raise all this money. But usually the journey is more like this, where you're like literally wading through shit. And I don't know if you guys remember that scene from The Princess Bride where like they're walking through this swamp with like the firebomb things, and then there's the rodents of unusual sizes, and Wesley's like getting attacked by all sides. Like that is literally what starting your own tech company is like. And so, the takeaways from that is that you need to be really truthful with yourself about why you're doing this. If you're doing this for money, don't do it, right? You have to really believe in what you're doing, because otherwise it's not worth it and you're just gonna wanna quit. But that said, I think, at least for me, the past couple months has been the most invigorating of my entire career, because I feel like I am finally practicing the law the way I would like to practice it, right? Efficiently, effectively, making sure that my clients are happy. So that's it. That's it for my presentation.
Amy will be around for questions. Right, Amy? Yeah. Great. Up next, Kyle Mitchell.
Thank you so much. So we have the whole screen, don't we? Oh, Lord. Okay. First of all, thank you so much, Mark. Live demo, it doesn't count, right? Here we go. So the contracts round 2, how riveting is that? Who deals with contracts? You read them, you write them, you sign them. Hopefully if you sign them, oh, that's right. Microphone. Who deals with contracts? Read, write, sign. Hopefully if you sign, you read. Great. It's terrible, right? Universally. Pretty terrible experience. Software, too, has some of those problems, right? What works all the time? What works great but doesn't steal your data? What installs first time, every time? It's pretty terrible. My name's Kyle. I'm out of Oakland, California. I write contracts in software. To give you a sense, open forms I have for open source contracting, or selling a web service, or 16 NDAs that meet every use case I can think of without using strange archaic language. Let me show you some of that. Oh God, I hope there's an internet. There is no internet. There we go. So here is a big long contract. This is for developers who want to do open source work as well as proprietary work for the clients. Irrelevant. It's nice and pretty. And it's on the internet, and I can send links to it. There are little notations in the margin, hopefully not too many of them, that are yelling at me, because as usual, when I write contracts, I fall back on legal language, or I say things long when I should say it short, or I say things that Ken Adams in his book says you should never say, or I define a term and never use it, or I use a term and never define it, or I reference a section that doesn't exist, screw up the formatting, the whole 9 yards, which make your contracts experience so lovable and enjoyable every time I work with you. The obvious answer to that is software, and I am by no means the first person whom this has occurred. In fact, I've seen references going back into the 60s for people who had this pretty well figured out. Published, usable are different things. There are many commercial options you can get that are available. I've written one called Common Form. What do I want? If you care about contracts, if you have to care about contracts but don't really care about contracts, I want to work with you. I want to work with you in the same way I work with my nerd friends. And some of that goes under the banner open source. Some of it is just that we will help each other out. And there's code out there that I've worked on with 7, 8, 9 people I've never met that has no license on it that we're all using. And it's this collaborative process that's facilitated by tooling and an approach to how we build contracts that's different from the way we build contracts at law firms. When I say I want to work with you, I don't want to hire you. I don't want you to hire me. I want us to get along and move the state of the art regardless of that. What does that mean? We have some big hurdles. The first is we need a way for computers to talk about contracts. Microsoft Word is where content goes to die. You can copy it and you can paste it and you can move it from graveyard to graveyard, and it lives this kind of zombie life thanks to the C and the V key, which get pretty shiny on your keyboard when you practice contract law. But that's not good enough for sharing little bits. What I wish I'd done as an associate starting off very early on was put every little piece of language that I liked on a note card and told myself where it came from and how it was built so that I could slot it in. And that would be faster than copying and pasting and not realizing what I should have changed but didn't. Or pulling a dusty form in a fit of expedience, which is the whole practice of law, and trying to make it fit the client. So Common Form is a tiny little language for expressing data in ways that computers can understand, and it makes it really stupid simple to write things like, let's go through Ken Adams' Manual of Style and Contract Drafting, note every single term he says is bad sauce, and point it out every time I use it, or every time I says hereas, or wherein before. I'm getting better at that. It still happens every once in a while. When you have structured data, and that is what we're looking at a contract in structured data. If I replace Common Form with the API, I get JSON. It's dead simple to work with. We've been there. Document assembly, ticked. I can give you command line tools. You can do what I do. When a client comes to me and says, I need an option packet again, actually I need 9 of them, I can just spit them out. Right? Command line tools are available for that. You can do it online, as we've seen. And this is editable. You can go in there and do whatever you want. You can move stuff around. You can define terms that'll yell at you when you fail to do that. Sorry, somebody else's computer. It's an editor. Okay, we've been there. I could show you the same thing in Vim in a terminal that the nerds use, right? Which is where I really want to be secretly, in the terminal, 72 columns back in 1970. But we've been there. Why is this interesting? Why is this new? You can go and get a commercial solution. It plugs right into Word. Okay, you're in the graveyard again, but it'll work, and it's faster if what you've already got is Word documents. What I'm trying to do is make it possible to share. This little code at the top, this is the only piece of technology you really need to understand how you can share content with lawyers. This little code is like a fingerprint of this entire form. It's what's called a cryptographic hash. A hash is just a kind of math puzzle that's really easy to work one way, like 2 + 2 = 4, but really difficult to work the other way. If I say 4, what adds up to it? You can say 2 and 2, 3 and 1. Cryptographic hash functions do not work that way. If I give you this big long string, which encodes a number, it is really difficult for you to give me a form in this data language that produces this fingerprint. And it's not just the form, it's every part of it. So for the nerds out there, this is the Git tree model. This is a Merkle tree. This is a hash of hashes, right? So if I change any part of, sorry, this Macintosh technology. So this one starts BFDC. If I change any part, again, awesome terms, the whole fingerprint of the form changes. It's completely different. That makes that code a unique identifier for anyone who has seen this form. I can say, hey, we should use A67A, AB, ... put in a hyperlink on our deal. And you can go through here and fill in the blanks. The date, for example. You can click this button and get a docx. The blanks you filled in never go to my server. I don't want them. Keep your client's name off my server, please, right? And it's dead simple to drop additional blanks in here. So it's real easy to send this to clients and say, fill it out, especially if all the blanks are at the top. Click the button, you got a docx, you can send it to opposing counsel. They have no idea about all this newfangled nonsense. Those things aren't easy to reference. They're big, long codes. That's part of why I know that two forms aren't going to end up with the same fingerprint, because there are just so many possible fingerprints. But what a service like the server that I've written does is let us assign names and versions to things. So here's my version of plain English startup incorporation documents. Been beaten to death startup incorporation documents. This is my chance at the hammer. But every one of these has a name that's associated with me, so, or rather the project. So Ironside/bylaws, the first edition, fourth draft, is exactly this form. If I say, here's a link to this form from this person at this version, I can be guaranteed that when you click that button, either it will fail because I have broken the software again, which is happening less and less frequently these days, or you will get exactly the terms that I want to propose to you. If I give you a password, you can stick stuff on the server. And there's a difference between sticking it on the server and saying, here it is, come up with a fingerprint, give me a link that I can use to share it, and saying, here it is, oh, and by the way, I want to associate with that with my name. I want to say that's my perfect set of corporate bylaws, first edition. At that point, it's public, it's published. I can index it. I can give you a search box that says, you want to see every definition of Exchange Act, and they're basically all the same, but there's an amazing amount of variation if you go on, say, Edgar. I can do that. I can do that search on the published forms, the things that people have ascribed to their name. There are many, many more forms on the server that are just available if you know that code. And that makes it very possible for me to say, okay, you wanted changes. We're off my preferred form. It happens. It's the practice of law. I can save my changes or your changes onto the server, get back that little code, send it to you by email and say, is this what you meant? And I still know when they follow that link, either something's going to go terribly wrong, less and less frequently, or they will see exactly the terms that I have in mind. And they can do the same for me. What does that mean? We can share across practices. As long as you're not typing your client's name or the purchase price or the intellectual property you're tracing or the security that you're creating a derivative of, you're leaving those blanks, and we can fill those out really easily and actually automatically. We're trading generic forms. Instead of drafting it in Word for this specific deal, we're dealing at the level of the awesome forms you occasionally get at CLE, where someone said, man, the practice really slowed down these last 9 months. But all I do is bankruptcy settlement. And I went back and read all of my bankruptcy settlement agreements for the last 12 months and distilled the state of the art. And everybody's like, wow, we should give you like 1,000 CLE hours for this, because it's gold. But that happens in a practice maybe once every few years. Here in New York, maybe more frequently if there's a very active bar. But for the most part, we're siloed, right? Because of confidentiality, which is like privacy plus plus, we have that structural constraint. So this is an attempt to deal with it. Yes, it's document assembly. That's not altogether exciting. I'm excited about it because I can automate it, and it's open source. You can use it for free. In fact, everything you've seen is open source. You can use it for free. And it makes it dead simple to write other tools. So at the risk of a plug, this took 2 weeks. You want to do an NDA? I am tired of reading them. And I'm tired of charging for them. Yes, it was new. I've never seen that one before. Yes, it said pretty much what I thought it was going to say. Yes, there were some interesting stylistic variations, or maybe there was something in there that I hadn't seen before and that now I'm going to steal in my form. But for the most part, it's a quarter hour that I would rather have back and they would rather not pay for. So build a little service that just lets people pick a form and send it. Fill it out, e-sign, and it's dead simple to teach software to pack together a docx, put some signatures on it, do some public key so that the server is validating that it saw a valid signature, and send everybody a copy, automated. So it's not that this is a great product. It's that once you have that lower level, where you have software that can talk about contracts in a structured way, it gets so much easier to write. Help me not use those terrible old terms. Help me make sure I haven't broken my references, my definitions. Help me do different formatting options. And we can do that on the web. If normal in your practice area is decimal numbering, kind of like Commonwealth numbering, 1.1, 1.2, 1.7, that kind of thing, you just tell the software, I would like that, please. If you want a title, give it to me, and we'll spit out a docx so you can use it to pass. That's document assembly. What I'm really interested to talk to people about, to share with people, to work on with other people, is can we find a combination of that document assembly stuff that we know so well for about the last 40 or 50 years, but find a way to make it so that we can actually collaborate as attorneys without just waiting to see, oh, he had something in his merger agreement that I hadn't thought of, or they got around to fixing their NDA in response to the federal trade secret legislation before I did. I'd like to speed up how fast that happens. I'd like to make law a little bit more collaborative. So please try to break the tool, commonform.org, see if you can break it. It's one of my favorite pastimes. If you want to work on it, let me know. If you're interested in the forms I've written, let me know. I've had people come to me who are really interested in that kind of what software people call lint program. I am writing and I'm seeing as I go along the obvious mistakes that I've made, that feedback loop, which changes the way you draft contracts. I've been doing it about 2 years, and I have this much respect left for my ability to tick all of those boxes and keep all of those bad practices out without some kind of automated assistant. Because I thought I had it down, and then the software showed me that I didn't. If that's of interest, if the privacy concerns are of interest, if you want to write a templating system, I've done that on the command line, you want to do it in the browser, let's go. But let's get some kind of way that we can advance the state of the art together, and we don't use firm or confidentiality and the really real practical implications of dealing with that day to day and preparing agreements for real clients. Let's find a way to unhitch the progress of contract drafting from those structural constraints. That's what I'm after. So I'm sorry?
What platform is that written on?
Because it was destined for the browser, everything is currently in JavaScript. I'm indifferent, it works. Node.js, it'll all run on the command line as well.
So all of the code is JavaScript that you wrote?
Currently, yes. But there's nothing computer science-y difficult in there. You need implementation of the hash functions. That's about as low level as it gets. All done?
Okay, up next, I'd like to invite up Remco de Nicker from IBM.
Did you have a presentation? Yeah, it should be online, right? All right, so I work for IBM. I'm a developer advocate. I've been working with legal hackers for a few years, also in my previous jobs. I think I'm really interested in legal language as a subset of human language. So I think it's sort of the first step towards removing humans from the whole process. So I think that's quite a challenge. So what I wanted to present here is how easy it is to actually get started with a lot of these legal tools. We've been, like a lot of people have been talking about what we should be doing, where we should be going towards, but the step from design thinking to actual implementation is much smaller than you might think. Just touching upon these 4 points, cloud, any startup, any growth company should be on cloud. A lot of the tools are on cloud. I want to talk about Watson as an NLP engine, blockchain, and then quickly data science. So this is IBM's cloud platform, and there's about 200 services on there, but the main ones I want to talk about was the conversation, which is the essence of a chatbot, the discovery, which is sort of an enterprise search or an NLP analytical search engine, and that consists also of natural language understanding, which helps you break down text and structure text and analyze it. Both of these can be trained by custom models using the Watson Knowledge Studio, which is sort of this tool. So I'm not sure if everybody can see this, but this is basically as simple as a chatbot will look like. I think I can teach anybody how to build a chatbot in probably 30 minutes. You know, it's like developer or non-developer. It's like super simple. It's essentially you're building a dialogue tree, and there's like no coding involved. You just write down your tree of the dialogue that you recognize at an abstract level. You implement it, and the tool itself will recognize where in the dialogue the user enters and guides the conversation from there. So it's super simple. It's so simple, I hate to talk about it very often to developers because it's really boring. This is the discovery tool. So the discovery tool, who's familiar with enterprise search systems that can index like thousands, millions of documents, and you can do these analytical text contextual searches. So that's basically what this is. You have your data. You create sort of your custom model by annotating the text, breaking down the text, and then you have your queries against the documents that you stored, and you get your outputs. So this is just the UI for the service. This is just a view on an indexed set of documents. This is just the query view, so all these services are available through APIs. So for developers, you build this as a non-developer, as a domain logic expert, and then the developer sort of makes use of it, consumes it. Same thing with this one. But then the more interesting part is this Watson Knowledge Studio. So as a domain expert, as a lawyer, you can look at your text and you can annotate it. The way I think the New York Times has this whole human annotation project going on with their news indexes, their corpus. And you as a lawyer can do the same thing. You upload your document, you annotate it. I'm building with one of the IP lawyers at IBM. I'm building this patent claim analyzer. So he's doing all the annotation. And this is an example. So I create these entity types that are the basic building blocks of my sentences. So if you saw the previous presentation, the common forms, it's roughly been doing the same thing. Like you create your building blocks of your entities in the sentence, you annotate it, and then you add the relationships between the entities, and that's sort of your abstract document. And then also you build your dictionary. So if there's like legal terms, you build your domain-specific legal terms in a dictionary, and the two together are being generated into this custom model that you can then, that's basically the value of your business. That's applied to all kind of documents that you have in your discovery tool, for instance. The next part is blockchain. Who's not familiar with blockchain is a better question these days. Yeah, and as it should be. So I think blockchain is for multiple reasons interesting. It's not just a financial assets management system, but it's anything of value, which could be data or anything else that can be exchanged between parties. So it can be applied in many ways. But amongst others, also smart contracts. You know, so I think as a lawyer, maybe smart contracts is of interest. This is on our cloud system, like with one click, you install a whole blockchain service, a whole blockchain network. So it's really great to get started if you want to play around with it. This is an example. And this is the data science experience. So once you have the previous natural language processing tools, that will give you some hardcore data that is more structured, that can be used for statistical input. So if you have all your analytical data from the NLP, you'll have now your structured data, your probabilities, that you can then use in statistical analysis. So that's the next step. But this is more for statisticians, I think. The other purpose that I wanted to say, if you're, I like to work with legal hackers. So if you're anywhere in one of these cities, we have developer advocates like myself there. So if you want to connect to IBMers, and we can do anything from workshops, collaborate with you on projects, give like trainings, whatever. Then call it out. If you're not in one of these cities, try contact me anyway, because we have like 380,000 people around the world. So there's always someone somewhere from IBM, I've noticed. And this is my contact information. All right. So that's all I wanted to talk about today. Any questions? No? Okay, good. Thanks.
Everyone, so we have a new round of coffee in the back. We're going to take a quick... Sorry, hi. We're going to take a quick break. We got new coffee in the back, so let's break for 15 minutes and then get right back into it.